Hi everyone. My name is Andrew. I'm an associate at Schindlers Attorneys, and I'm just here to fill you in on the current weed laws as they've developed and as we presently know them. We came into this space by representing the Dagga couple from about 2013. We represented them in the High Court and eventually in the Constitutional Court. So we've had a fair amount of time to come to grips with these laws. So hopefully I can provide you with a little bit of certainty. So I'll start with the hot topic right now, which is recreational cannabis. We don't have much of a recreational industry in South Africa yet. There was a lot of hype over the Constitutional Court judgment, but it didn't do a lot in the way of actually giving us any kind of industry. All that the Constitutional Court judgment allows us to do as adults is cultivate and use cannabis in private for your personal consumption. You can't sell it in a recreational space. So there's a lot in that ruling that one has to come to grips with. The first is that they didn't set a limit. The court said that Parliament needs to give us a numerical limit as to how many grams of cannabis we can have or how many plants we can grow. They haven't done that yet. Right now, the responsibility lies with the South African Police Service. They are the ones who are supposed to decide what is and is not too much cannabis. So if they catch you with cannabis, they will look at the amount you have and they'll ask themselves, is this amount for personal use? If in their minds the answer is no, then they have every right to make an arrest. Fortunately, you'll have your day in court where you'll be able to explain yourself. And what we've been advising clients to do is if you're concerned about how much cannabis you're growing or using, keep a diary. Keep a dated diary and keep detailed records of what you're doing with your cannabis, how much you're growing. If you're making extractions, give us the exact numbers. Say I'm using X amount of kgs of cannabis to create this much cream, and then I use this much cream to treat whatever disease it may be. So that just gives you more to hand up to a judge than your opinion on what you are doing. So because I can't give you a limit, the best I can do is give you advice on how to have your best day in court possible. So that's how we think you should do it. The second thing is, what is a private space? The Constitutional Court explained to us that private space means more than just your own home. So that means there's more than one private space. You can smoke it. Now they didn't go into too much detail as to what is and isn't a private space, and you can chat to us on stand 63 about what we think it is. But the implication is that because you can move from one private space to another, you must be able to have cannabis concealed on your person in order to move between these private spaces. So to that effect, the National Commissioner of Police signed a document that was supposed to serve as guidelines as to how cannabis should be policed. Obviously it keeps getting policed differently, and that's, it's an enforcement problem, not so much a legal one. But in that document, it confirms that you can move between public spaces, you can move through public spaces between private ones with cannabis concealed on your person or in your car, or even, if you want to be brave about it, domestic flights. So, on a strict interpretation of the judgment, and after having seen that document, we think the legal position is that you could fly with cannabis in your luggage. However, that doesn't stop you from having your flight potentially ruined by law enforcers who think they're doing the right thing. So we would advise caution if you do plan to fly with it. So that's really all there is to it when we talk about recreational cannabis. You can't sell it, but you have some personal freedoms when it comes to using it and cultivating it for yourself. Now, there was a notice published this year in May dealing with CBD. So what this notice does is it exempts preparations containing CBD, so let's call them CBD products. It exempts CBD products with a daily dose of 20 milligrams of CBD or less, and a product which does not make any health claims. So you have your product that has a 20 milligram daily dose of CBD. It's not allowed to make any health claims pertaining to any particular disease. So you can say this is for your general wellness, but you can't say use it to treat things like insomnia. So if you meet those two requirements in terms of that notice, you can sell your CBD product exempt from the scheduling of the Medicines Act. So the implication then is because it's exempt from the scheduling, you would think that the Medicines Act can't interfere with the importing of these CBD products. And there have been a lot of people here who have come up to us today, again at stand 63, who have explained to us that Port Health has recently seized their shipments of CBD products. And these CBD products, they tell us, adhere to the notice. So some of you may have noticed that SAPRA issued a media statement shortly before they started doing this. And in that media statement, they say that you need a medical license in order to import CBD, even though it meets the requirements of that notice and is therefore exempt from the scheduling of the Medicines Act. We believe that they're wrong about that. We wrote a letter to them calling them out, explaining our position and explaining what we believe to be a very strong legal point. We haven't received a response yet, but if you are one of the people, and we only found out this was happening about 3 days ago, if you're one of the people who have had your CBD products seized or detained, come speak to us. We'd love to have a conversation, a longer conversation about that. So, recreational cannabis, summary. Grow it and smoke it for yourself, you can't sell it, and CBD that meets the requirements of a 20 milligram daily dose, or a 20 milligram daily dose and it doesn't make health claims. You can sell that product. So that's about all there is to the recreational side. Now the medical side of things is being governed by laws that were enacted while cannabis was illegal. So they don't cater for every single aspect of cannabis. They don't give us certainty in the way we would want it. So the present medical license that you have to apply for is the same medical license that any producer of a medicine would have to apply for. For example, Ritalin or some kind of painkiller. Because of that, it's notoriously hard to get any kind of medical industry and cannabis industry going in South Africa. Because if I was to hand you a medical license today, there's not a whole lot you can do with it. You can export, the medical license gives you the right to export, but who would you supply it to in South Africa? You can't deal directly to the public, if that's what you were thinking. The only people you'd be able to sell this to is a pharmacist. The pharmacist would then take that cannabis and synthesize a medicine. That medicine in turn has to be registered. The registration process can take anywhere from 2 to 5 years. So until there is a cannabis-based medicine that is registered, there's nothing to do with medical cannabis in South Africa. And once those medicines are registered, they'll be sold by pharmacists in pharmacies, not in dispensaries. Dispensaries will be a recreational undertaking. So that's really how the medical side of things works. You get your license, you cultivate your cannabis, and you export it, or you supply it to some pharmacists who can take the 2 to 5 year slog of actually trying to register this medicine. So, aside from what I've just set out for you, there's no permit or license in existence that allows you to sell cannabis. It's that one medical license that allows you to profit from cannabis in some way. Now again, these are old laws. We're expecting new ones, and we hope to see new ones in September 2020, being the Constitutional Court's deadline for Parliament to enact their own laws. We think we'll see something. We don't know what the extent of their changes will be, if any. But until then, we're left with old laws that were written while cannabis was illegal. So trying to squeeze cannabis into that old paradigm is very difficult. And because of that, we've seen massive delays with SAPRA issuing licenses, with people being in the dark as to what they actually need to do to get a license and what they need to do once they have one. It's a lot of uncertainty, and it'll only really be fixed until we receive new legislation. So cannabis is too diverse a commodity to try and squeeze into old laws that aren't custom made to properly govern it. So new regulation really is the only way. So that's the basics of our medical and our recreational cannabis regimes. What I'd like to do now is just take the rest of the time to answer any questions you might have. We've got a microphone here that'll come to you in the audience. So yeah, I'd love to chat to any of you guys one-on-one if you have any specific questions. No questions? Okay. I must have made that pretty clear.
I've got a question for you.
Thanks, Jules.
Can you explain the 20 milligrams a day? What if I bought a 1,000 milligram bottle of CBD from over here? Does that mean I can't finish the bottle within 50 days?
So the onus is really on the person selling the CBD. The product that they claim meets those requirements must actually be capable of being divided up into 20 milligram daily doses. If I sell you a lollipop that has 25 milligrams, I can't tell you you should have this lollipop in X amount of licks. And in having these individual licks, you'll attain the limit. No. So there's a bit of common sense that goes into it. So yes, a dropper that has 1,000 milligrams, if it's capable of being divided up into single 20 milligram doses, then we think that meets the requirements as clearly as they could.
Thank you.
What about CBD under 20 milligrams in food? Is food a different set of laws to any other preparation?
Sorry, I don't think I heard the question there. It was relating to CBD?
In food.
In food. In food. Oh, in food. Yes, okay. So how we understand the notice that was released when it comes to exempting CBD is that it's exempt from the operation of the schedules of the Medicines Act. So no medical laws could stop you from putting CBD in your food. However, there is a new set of laws that's now entered the fore. Again, we have to try and squeeze cannabis into these old laws that weren't designed for it. There is the Foods, Cosmetics, and can't remember the third word, the Foods, Cosmetics and Something Act. And what the Department of Health are now doing is saying that food items cannot contain a prohibited substance. And because of that, they're giving people who are putting CBD into food grief, because they're arguing that CBD is a prohibited substance. But now, prohibited under what law is our question, since the Medicines Act no longer applies to it. So it's a very new debate. It's really only we've only come across it in the context of people having their food items that have been imported detained by Port Health. So we're sinking our teeth into that, but our gut tells us there's definitely a strong legal argument to be made against them doing that, since it's been allowed for a certain amount of time anyway. They can't arbitrarily issue a media statement and then go off and do their own thing and then come back and say, but we warned you in that media statement. The media statement has to be correct as a starting block, and we don't think it is. Cool guys, thanks. Enjoy the rest of the expo. We're at stand 63 again, and yeah, we'd love to chat to you more in depth about any questions you may have. We're just giving out free legal advice this entire expo. There's meeting rooms. If there's stuff you want to show us, private documents, let us know. Cool, enjoy. Thanks guys.